Test 1, 2, 3, 4 testing.
Good morning, everyone. The committee will come to order. I'm glad to be here today to consider my bill, H.R. 705, the Veterans Second Amendment Protection Act, and Ms. Stefanik's bill, H.R. 4562, the Ernest Pelt Accrued Benefits Act. I will be recognizing myself to speak on H.R. 705 in a moment. I do want to give my support to the goals and ideas of H.R. 4562. The pension benefit is one that many families rely on to pay for expenses, and it does not make sense to cut these benefits off the month before the veterans pass. I look forward to working with Ms. Stefanik and others to find appropriate offsets for the bill. I would like to welcome all of the witnesses here today to testify on these two bills. And I am looking forward to a thoughtful and healthy discussion on the legislation before us. I also ask unanimous consent when she arrives, our colleague, Ms. Stefanik of the New York, to be allowed to sit and ask from the dais the questions of witnesses today's hearing. Hearing no objection, so ordered. I now yield to Ranking Member Takano for any opening remarks he may have.
Well, thank you, Chairman Boston. Thank you to all our witnesses for being here today. Speaking to H.R. 705, I have to say that this bill is ill-conceived and unwarranted at best, and potentially dangerous to veterans and beneficiaries at worst. My Republican colleagues have once again eschewed evidence-based, data-driven policymaking and have instead embraced unnecessarily partisan legislation or legislating based on anecdote and soundbite. The title of the bill is a case in point. Being provocative from the start prevents us from having a real conversation about real and important policy that saves lives. Republicans have failed to clearly identify or quantify the alleged problem they are attempting to address, and they have yet to even figure out what their preferred statutory change is. In fact, we have been told that the legislation we have before us today is not the version that will move to markup after this hearing. That version has yet to be seen and will not have been vetted by the members of this committee, VA, VSOs, and other stakeholders prior to the proposed committee action next week. So it is clear that my colleagues have spurned any attempts at sincere bipartisan discussion on the issue at hand and have entrenched themselves in tired and false arguments about the rights of veterans somehow being at risk when nothing further from the truth when there can be nothing further from the truth. First, I would like to address the idea that veterans are declining to seek mental health care for fear that VA will confiscate their firearms or prevent them from purchasing new ones. Now, I have no doubt whatsoever that this fear is real among veterans and does serve as an impediment to seeking care. We have all heard that charge. However, the failure of my colleagues to condemn and counter the misinformation that leads to such a sentiment among veterans is as infuriating as it is damaging. I know, as does everyone on this committee and among the VSOs, that however real that fear is, it is also unfounded. Under no circumstances does VA ever confiscate anyone's firearms. And let me be clear about this, under no circumstances does VA ever confiscate anyone's firearms. And seeking mental health care from the Veterans Health Administration will not result in your firearms being taken away. VA does not have the legal authority to do so. And only under a very discrete set of circumstances and for a very discrete population does the Veterans Benefits Administration report veterans to NICS. VHA never does. So I asked my colleagues and I asked the VSOs, what is your response to the veteran who expresses fear their firearms will be restricted? Because if it is anything other than an unequivocal, that is not true, go get help, then you are perpetuating that stigma. And this bill traffics in that same disinformation. It is a deliberate attempt to scare veterans, and that scaring is what is doing the real harm. Now, moreover, with respect to the protection of a beneficiary's Second Amendment rights, there are no less than 6 avenues already available to a claimant for redress. How many more layers of government bureaucracy are my colleagues suggesting that we add according to data from VA? These are the 6 avenues right behind me. Most of those avenues for redress are even widely used by claimants. We have not seen claimants use these 6 avenues. In fact, in fiscal 22, only 135 claimants out of roughly 22,000 who were newly assigned a fiduciary appealed the incompetency determination, and only 33 sought relief from NICS reporting. Adding more layers to the 6 we already see here to this process, I think, is unnecessary. A second argument I would like to address is the charge that the claims adjudication process is inadequate to discern between those who require a fiduciary because they are bad at math and those who have a mental illness or a condition that makes them a danger to themselves or others. In many ways, that distinction is immaterial. But in general, it is clear that the fiduciary process does serve as an adequate proxy determination for potential dangerousness. It is important to acknowledge that there are significant data gaps that exist related to the population of beneficiaries in the fiduciary program. H.R. 705, by the way, addresses none of those data gaps, which is one of its many flaws. But here is some of what we do know. Among beneficiaries assigned a fiduciary because of a mental health condition, the most common conditions are as follows: schizophrenia, 36.5%, traumatic brain injury, 31.2%, PTSD, 22.3%, bipolar disorder and dementia, 10%. Mr. Chairman, all these disorders are associated with elevated risks of dangerousness to self or others. Suicide in particular, as are a host of other factors that are actually concentrated in the veterans population. Moreover, we also know empirically that veterans who are found to have poor financial management abilities are also 2 times as likely to have substance use disorders, suicidal ideation, engage in violent behavior, and be in the justice system. So drawing a distinction between those who simply cannot balance their checkbook and those who are more explicitly dangerous to themselves or others is not warranted, and in fact could cause more veterans to slip through the cracks. So, Mr. Chairman, suicide prevention has been VA's highest clinical priority for years. It is a priority I share with countless others on this committee and the VSO community. I am not questioning anyone's sincerity in wanting to prevent veteran suicide, but going back to data-driven, evidence-based policymaking, here is what we know for certain. Firearms are used in over half of suicide attempts nationally. Suicide attempts, number 2, suicide attempts using firearms are lethal in over 85% of cases. 3, firearms account for 70% of male veteran suicides and 50% of female veteran suicides. And veterans, number 4, are 3 times more likely to die by suicide than the general population. So it begs the question, if we all care so deeply about preventing what is clearly an epidemic among veterans of death by suicide using a firearm, why would we pursue a bill which addresses no clearly defined problem, the only clear result of which would be the removal of a safeguard that puts more guns in the hands of the most vulnerable beneficiaries VA has? The answer, as I alluded to earlier, is simply this: it's politics. Mr. Chairman, I yield back.
Thank the ranking member. Don't necessarily agree with everything he said, but we have 2 panels before us today, so I will be holding myself to a 5-minute speak on my bill. Now, I recognize myself for 5 minutes. You know, I'm proud to have introduced my bill, H.R. 705, the Veterans Second Amendment Protection Act, again this Congress. My bill would prohibit VA from sending a veteran's name to the FBI's National Instant Criminal Background Check System, or NICS list, unless there is first a determination by a judge or a court, like anyone else who is not a veteran, that says that person could be a harm to themselves or others. In some cases, VA will appoint a fiduciary to a veteran or a VA beneficiary to help them manage their VA benefits. The appointment of the fiduciary does not, I will see it repeated, does not indicate the person is dangerous or mentally ill. It is about their ability to manage their financial benefits. Hundreds of thousands of Americans, including veterans, have fiduciaries. But when it comes to our veterans, the minute a VA appoints a fiduciary, that veteran's name is automatically sent to NICS. So when the ranking member says that the VA does not take their guns away, they don't. They report them to NICS, and then their guns are taken away by another agency. The veteran is now prohibited from purchasing a firearm based on the decisions of the VA employees, not a court's finding. My message remains simple. VA should not be able to take away a veteran's Second Amendment rights because they need help managing their benefits. Veterans should not be treated any different than every other American citizen. Even criminals have to be convicted of a crime in a court of law before their names are reported to NICS. Let me say that again. Even criminals have better due process rights than the men and women who fought to protect our constitutional rights in the first place. Veterans are not being reported to NICS for much less than this injustice practice. So this unjust practice must end. A little over 8,000 U.S. veterans and beneficiaries have been reported to NICS since the beginning of last year alone. 8,000. Why are our veterans losing one of their constitutional rights because they need help managing their VA benefits? You might be thinking, surely VA doesn't that they do additional screening with a psychologist, a doctor, a therapist, the veteran's family, or anyone else for that matter, before they turn them over to the NICS. They don't, and it is unacceptable. We know that practice creates a stigma around getting veterans into VA to get the care and services they have earned. That might not happen if you're from a city and you are not using your Second Amendment rights on a regular basis. It does happen if you're from flyover country. I have been hearing from veterans across the country for years, and it's time it stops. We should be breaking down barriers when our veterans are telling us why they won't go to the VA, not standing idle like our hands are tied. My legislation is not about guns on demand. It would add one step so the veteran can have their day in court before they lose their constitutional right, as any American should expect, which is something we should all care about. I want to thank the Mission Roll Call, the National Defense Committee, Veterans of Foreign Wars, the American Legion for their support. Together, you have represent millions of veterans' voices nationwide. Once again, this bill is not about guns on demand, but about due process and the Constitution, which is the bedrock of our republic. In my life, I tried to count it up this morning, how many times I raised my hand and took an oath to uphold and defend the Constitution of this United States, whether it was as a member of the armed services, whether it was an elected local official, whether it was a state elected official, or whether it's been here in Congress. And I'm going to do just that, because what we are doing right now, and the reason I'm carrying this bill, to what we are doing for veterans who are seeking help is unconstitutional. There's no due process. I look forward to hearing comments and having input and having a debate over this. And now I will yield back the balance of my time, and I will now invite our first panel of witnesses to the table, which they're already there. Testifying before us today, we have Mr. Ron Burke, Deputy Undersecretary of Policy and Oversight at the Veterans Benefits Administration for the U.S. Department of Affairs. He is accompanied by Kevin Friel, Deputy Director of Pension and Fiduciary Services at the Veterans Benefit Administration for the Department of Veterans Affairs, and Mr. Dave Behrens, Chief Counsel of the Benefits Law Group in the Office of the General Counsel at the Department of Veterans Affairs. I ask the witnesses, if they would, please stand and raise your right hand. Do you solemnly swear that the testimony you're about to provide is truth and the whole truth and nothing but the truth? Thank you very much. Let the records reflect that the witnesses have answered in the affirmative. Mr. Burke, I now recognize myself for 5 minutes recognize you for 5 minutes to give your testimony.
Chairman Bost, Ranking Member Takano, and other members of the committee, thank you for inviting us here today to discuss pending legislation which would affect the Department of Veterans Affairs programs and services. Joining me today are Dave Behrens, Chief Counsel, Benefits Law Group, Office of General Counsel, and Kevin Friel, Deputy Director, Pension and Fiduciary Service. Mr. Chairman, I will highlight both bills in my opening statement. We have provided detailed comments in the full testimony describing areas of concern that VA has on both pieces of legislation. At VA, we believe that veterans, their families, and survivors have earned and sacrificed for our country, and now it is our job to care for them. With these principles in mind, VA opposes H.R. 705, the Veterans Second Amendment Protection Act. VA appreciates the committee's focus on Veterans Second Amendment and due process rights. However, we do not support a bill that would conflict with existing statutory reporting requirements of the Brady Handgun Violence Prevention Act, otherwise known as the Brady Act. In accordance with ATF regulations and DOJ guidance, VA reports all individuals determined unable to manage their VA benefit funds. Such a determination must be based on definitive medical evidence that is clear, convincing, and leaves no doubt as to the person's inability to manage their financial affairs. Once a proposal of incompetency is finalized, VA notifies the beneficiary orally and in writing and reports the necessary information to NICS. When notifying the beneficiary of the determination, VA provides information on how to request relief from Brady Act restrictions, and when deciding a request for relief, VA considers not only the beneficiary's individual rights, but also the safety of the beneficiary, their family, and the community. In addition to complying with federal law, VA's reporting to DOJ is a matter of veteran safety, which is of utmost concern to VA. In fact, VA's top clinical priority is veteran suicide prevention, utilizing a whole-of-VA approach that integrates strategic planning, program operations, and program evaluation across VA. Scientific research shows that mental health is one clear risk factor for suicide, and use of a firearm in a suicide attempt significantly reduces the chance of survival. Veterans are significantly more likely than civilians to use firearms as a suicide method, with an extremely high lethality rate of 90%. When firearm access is denied, only 1 out of 5 would-be gun suicide attempts later died from suicide by substituting another lethal method. It is VA's mission to care for our veterans and their families, and the removal of the required reporting of veterans to DOJ would run counter to this. VA also opposes the Ernest Pelt's Accrued Veterans Benefits Act. This bill would result in different discontinuation dates and therefore disparate treatment between beneficiaries in receipt of pension based on existing rating or decision and beneficiaries in receipt of compensation or dependency and indemnity compensation. For beneficiaries in receipt of pension based on an existing rating or decision, the discontinuance date would be the last day of the month of death. For beneficiaries in receipt of compensation or DIC, the discontinuation date will be the last day of the month before death. Further, the bill would create incongruity as it relates to the month of death benefit by functionally eliminating that benefit in certain circumstances for surviving spouses of veterans in receipt of pension, while the month of death benefit for the surviving spouse of a veteran in receipt of compensation would remain unchanged. This would result in disparity between beneficiaries in equivalent situations aside from the benefit type the veteran happened to be receiving at the time of his death. VA is continuously working to deliver earned benefits to veterans and their survivors more effectively and efficiently. Unfortunately, this bill would result in a change in processing that would introduce automation and program limitations. These limitations would slow down the receipt of the month of death benefit and, as such, be detrimental to the surviving spouse on file at the time of the veteran's death. A surviving spouse who would have been able to benefit from expedited processing of a month of death benefit will be disadvantaged by the processing impacts of this bill. Surviving spouses of veterans in receipt of pension at the time of death would have to file for and be found entitled to accrued benefits in order to receive the veteran's payment previously paid separately as the month of death benefit. In contrast, the current month of death benefit may be paid automatically to the spouse on file and does not require that spouse file a claim. Across VA, we are committed to providing the high-quality care our veterans have earned and deserve. We continue to improve services to meet the needs of our veterans and families. We are grateful for the resources that Congress has provided to VA and pledged to do all that we can to ensure they are used as effectively as possible. Thank you for the opportunity to appear before you today. We look forward to working with you on this and future legislation. Mr. Chairman, this concludes my statement. My colleagues and I are prepared to respond to any questions you or other members of the committee may have.
Thank you, Mr. Burke. And now we want to go to questions, and I would like to recognize myself for 5 minutes to start this off. Mr. Burke, can you please explain to me why the VA is the only federal agency that reports citizens to NICS without finding them a danger to themselves or others?
Yes, sir. I can share that we're simply complying with federal law. It is VA's intent to comply with federal law and regulations and ensure that we're putting the safety at veterans first. Veteran safety is an extremely high priority for us, and we are simply complying with federal law.
Okay. Then I need to ask the whole panelists, or you if you want to answer, and I just need a yes or no. Do you believe that everyone that has a fiduciary is a danger to themselves or others?
I don't believe that everybody that has a fiduciary is a danger to others.
Then can you explain to me how the determination of incompetent for VA purposes is linked to being a danger to themselves or others?
So basically, the determination of a finding of incompetency, which leads to us reporting to NICS, is one that's based on clear and conclusive evidence that the veteran is unable to manage his or her funds. That definition is the same definition adopted by DOJ in their determinations. We don't have a compliance or an enforcement arm here. We simply have a reporting requirement.
I understand that.
We comply.
I understand that. You turn it over to the people that do have the enforcement arm. Correct?
Yes, sir.
Yeah. I mean, we're not disagreeing on the fact. What we're disagreeing on here is the fact that a constitutional right is not being secured for our veterans and can be taken away by a bureaucrat's ruling. That's a problem. Any other person in this nation, besides a veteran, can go and receive a fiduciary. They're having trouble with their finances at home. They can receive a fiduciary. That doesn't mean that they're a danger to themselves or others. If they are a danger to themselves or others, there are reporting bodies. It can be a family member. It can be law enforcement. It can be others. You and your office could say, we believe that they are. We believe that this person is danger to themselves or others. Then it goes to a court of law. What we're doing and what we're doing with the process, you can say you've interpreted the way you want, but what we're doing with the process is we're punishing our veterans for simply seeking help. That's the problem here. This is not about guns. It is about the situation of not using due process. Due process does not involve a bureaucrat. A due process has you go before a judge. Let me give a quick story. I'm the owner of a newspaper. I have a right to freedom of speech. If the government comes in, shuts down my newspaper without any warning, do you agree that there's a violation of my First Amendment? Do you agree with that?
Yes, sir.
Mm-hmm. So why are we applying the same situation through the agency for our veterans' Second Amendment rights? I don't understand this. When I first came to Congress, I heard, and I couldn't believe that this was what the interpretation of the VA was. I heard it from people in the coffee shops, heard it from people in the barber shops. My wife and I own a beauty salon. I heard it there. People talk at the Legion. People talk at the VFW. And they talk about the fact that they wanted to seek help, but all of a sudden there is a loophole that allows them to lose their Second Amendment right. I know that the ranking member gave quite a testimony on how he feels about this, but the reality is I'm not arguing about guns here. I am arguing about the fact that veterans are losing their constitutional right without due process. And why it is that I receive arguments from the VA or anyone else on why it is that I'm arguing this point and think that I want to endanger the veterans. I don't, because there's still a process like any other person. I stand and fight against suicide like anybody else. I want no veteran to commit suicide. But I also don't want any veteran to lose the rights that they were willing to fight for, that they took and raised their hand to defend the Constitution, to have something that is in right in that Constitution, have it taken away from them. With that, I'm going to yield back, and Ranking Member, I'll recognize you for 5 minutes.
Well, thank you, Mr. Chairman. Mr. Burke, does the status quo, in your mind, with regard to the fiduciary program and the fact that veterans who are admitted into the fiduciary program are reported to NICS, do you believe that that protects veterans and saves many veterans' lives?
Thank you for the question. I appreciate that. Yes, I do. I believe in the fiduciary program. It's put in place and protects some of our most vulnerable veterans. And we do believe that taking firearms away, not us, but the process, does protect our veterans. Preventing veteran suicide is the #1 clinical focus for VA, and we believe that the process works.
So you answered affirmatively to the chairman's question. Does everyone who has a fiduciary, are they a danger to themselves or others? And you appropriately answered no, that not every single veteran that has a fiduciary is potentially dangerous to themselves or others. But I think is it also true that many veterans who have fiduciaries, I read off at least a third of veterans in the fiduciary program are identified as potentially schizophrenic. Nearly as much are identified as with serious bipolar disorder, and that they have 8 times greater likelihood of suicidal ideations. And the fiduciary program, by reporting these veterans to NICS so that they cannot buy a firearm, would therefore be protective of these veterans. Is that correct?
That is correct, yes, sir.
So the chairman is making, I think appropriately, his concern about due process. Is competency, veterans' competency to handle their own finances, is that based on a bureaucrat's decision, or is there a process by which a veteran is declared incompetent to handle their finances?
There is a process for that, sir, and it requires clear evidence, medical statements. In addition to those findings, there is a proposed finding of incompetency, which gives a veteran due process rights. During that period of time, the veteran or his or her accredited representative can submit additional evidence for consideration that in some cases does change the determination or the proposal. There is a due process period of time before a finding of incompetency. It's only after due process has been served that the veteran's name will be referred to NICS. But it is not a bureaucratic process. It is one where clear and convincing medical evidence and or statements are reviewed as part of that.
So it's a medical evaluation, is that right?
In most cases, we'll get it from a medical exam, medical document, statement from a medical professional.
And are veterans informed at the time that they're going through this process that being determined to be mentally incompetent and to need a fiduciary would put them on the NICS list? Are they made aware of that?
Yes, sir, they are. As part of our requirements under the Brady Bill, we are required to make contact, and we do that both in writing and contact. And my understanding is that legislation was passed by a Republican House, a Republican Senate, and signed by President Trump, reaffirming the process by which mental incompetency is determined and by which also being put on the NICS list
would result. Is that right?
Yes, sir, that's correct.
So in fact, there is a due process. A due process does exist administratively, and that there are 6 levels of appeal. There are 6 levels where a veteran can seek to not be put on the NICS list, even as they're going through a process of being determined to be mentally incompetent. Is that correct?
So there is, in fact, a due process period, and in addition to that, there is a relief request process. Once somebody is placed on the list, there is a process for requesting relief as well. And
so this bill before us, as far as we know, would require that a judge be required to be involved in this. How would that affect this process? Would anybody be able to be protected at all from themselves if they're in danger? If we introduced what the majority is saying we should do?
Yes, sir. So in many instances, those type of records our claims processors don't have access to. And in order to get those records, we're going to elongate a process of making that determination whether a veteran is incompetent or not. And we believe, as part of suicide prevention, that those determinations should not be elongated, and we believe it causes further harm to veterans by elongating the process to secure those type of records.
Sir, I'm over time. Mr. Chairman, I just want to say that the judicial process that you're thinking of bringing in would effectively end VA's ability to put anyone on the next list, and we have at least 1/3 that definitely should be there, and I reel back.
Thank you for yielding back. Mr. Self, you're recognized for 5 minutes. Mr. Self.
Thank you, Mr. Chairman. I want to explore your using the Brady Act because somehow we've conflated this with suicide prevention as opposed to the superior constitutional right. Why do you think the Brady Act gives you the constitutional right to report? And let me expand the question. You said, are you the only federal agency that has read the Brady Act that way? It seems that you are.
I'm going to thank you for your question and ask my colleague from OGC to chime in on this one, if you could, Mr. Behrens.
Yes, thank you. So the Brady Act authorizes the Department of Justice to request and obtain records from any agency on categories of individuals identified in the Act who are prohibited from owning guns. VA merely complies with that requirement, so I don't think our interpretation is unique in that respect. Our interpretation is one
who else does it?
Well, the department, we verified that interpretation with the Department of Justice when they issued their regulations.
What other federal agencies make the same determination?
I can't speak for what other federal agencies do. Are you talking about determinations of incompetence?
Yes, exactly.
Yeah.
Report to the DOJ and then have weapons taken away under the Brady Act. What other agencies do that?
So as far as I'm aware, Social Security Administration makes similar determinations of the need for a representative payee. I'm not aware of other agencies that are making similar determinations.
Okay, we're discussing, it seems to me, hearing the chairman and the ranking member, we're discussing drama and emotion here versus the rule of law. The alleged problem that I want to discuss is the Second Amendment, because there is no judicial review here. I know of legislative processes. I know of judicial processes. Mr. Burke, you say this is not a bureaucratic process. What would you call it then, if you don't call it a bureaucratic process? What would you call it?
Well, the actual process of determining competency for a veteran is something that's been in our fiduciary portfolio for many years.
What would you call it if it's not a bureaucratic process?
I wouldn't call it a bureaucratic process. It is an established process that we follow. With respect to us turning those names over in accordance with NICS, we call that complying with federal law.
We have legislative processes, we have judicial processes. What would you call this? It's got to conform to eventually constitutional. And how do we get a court of law involved before you make this determination? Tell us, as Congress, how do we do that?
Well, I think, sir, one of the concerns we have about getting a court of law involved before was what I mentioned briefly a moment ago, is the concern that it could potentially or will elongate the process. And for us, with veteran suicide prevention being at the forefront of our clinical focus, we don't want folks in harm's way for an extended period of time to secure documents.
I got what you want, but we're talking about a constitutional right here that requires a high bar to take it away, a high bar. Anyone will tell you it takes a high bar to take a constitutional right away. That's what the chairman was referring to in his newspaper example. How do we raise the bar here before we take a constitutional right away? That's the question.
So, sir, I've spent my entire adult life either in uniform or serving those that were in uniform, and I'll continue to do that by doing two things: complying with federal law, which I believe we're doing in this case.
What's the highest federal law?
What's the highest federal law?
Yes, that's my question.
I'm not quite sure I understand that.
It is the Constitution. And therefore, it takes a high bar to take a constitutional right away. That's why the Second Amendment, we heard more words about, we heard a lot of words here today. The Second Amendment is very clear. It takes a high bar. I think my time is almost up. I will yield back after I say we need to establish a higher bar here, and you need to help Congress with how we do that. Rather than having the administrative state make this determination on a constitutional right. With that, Mr. Chairman, I yield back.
Thank you, Mr. Sell. Ms. Brownlee, you're recognized for 5 minutes.
Thank you, Mr. Chairman. So, Mr. Burke, we've discussed this bill several times in this committee, and I think on my side of the aisle, we have said, you know, if there's any way in which we can improve upon due process, we are open and willing to look at it. I think the chairman has made it pretty clear that there is a pretty extensive already process for due process. I guess my question is to you, is there anything that you would recommend to this panel of how we can improve due process from where we are today?
Yes, ma'am. I can tell you that VA is always committed and willing to collaborate with Congress on ways to improve. Happy to get, outside of the hearing, staff level to connect and communicate on ways that we may be able to improve.
Okay, and so how many, can you quantify, or do you have the data to know that how many veterans have used the due process and the various steps to reverse the opinion of the VA?
So I can speak to two things, and I think what you may be wanting more specific information is the actual relief process. All decisions from VA come with a due process period. With respect to the finding of incompetency and those that want to seek relief from that, I will tell you that the average age of the individual in our fiduciary program is 73. The average age of the person that seeks relief from being placed on the NICS list is 59. We had in FY22, we had 33 individuals seek relief. Of those 33, there were 12 that, based on submission of new evidence, had their competency level restored. And that was in FY22. We're on pace this year for very similar numbers. So it's not a large number of veterans that are seeking relief. When they do, they're significantly younger than the average age of the person in the fiduciary program. Again, there is an avenue even outside of due process where the relief process itself has resulted in determinations of the removal of the incompetency status. And when we report the NICS, we report three things: those that need to be added to the list based on a finding of incompetency, those that need to be removed from the list because they have been since found to be competent, and then 3, those that need to be removed from the list because they're deceased.
Thank you for that. Do you have, evidence-based data that supports the issue that this process indeed saves lives?
I can take that for the record and certainly provide you with a more detailed response.
Thank you. And so from your vantage point, how many veterans do you know who have had their firearms confiscated by the VA?
So I know right now we have approximately 109,000 active beneficiaries.
in our program, and those names would have been referred, obviously, to NICS.
Right, but does VA have the authority to confiscate firearms?
The VA has no authority to confiscate. We merely have a reporting responsibility.
So, and do you know how many veterans who have attempted to purchase a firearm who were denied because they have a fiduciary at the VA?
I don't have that data, ma'am.
Okay. I have no more questions. I'll yield back.
Thank you. Dr. Miller-Makes, you're recognized for 5 minutes.
Thank you, Mr. Chair, and I thank our witnesses for being here today. Mr. Burke, what level of VA employee is normally the one who would send the name to the NICS system, NICS system?
So we have rating veteran service representatives and other employees that make the determinations, and I believe the feed, if you will, of data from VA to NICS is done at our headquarters level, and that is an automated process on a weekly basis.
And what type of training do they receive?
All of our rating veteran service representatives, there is training on incompetency determinations and decisions. Medical providers, both vendor and VHA, are required to take incompetency training as well. And that is training that we track through our training management system and other modalities, but they are required to take that training.
And would you be able to send us what the competency training is?
Yes, ma'am.
Send it by mail, thank you.
Yes, ma'am.
Even if I accept the VA, and I'm a 24-year military veteran, married to a veteran in a family of 6 of the 8 children. My father was also military, as was my grandfather and my uncle. Even if I accept the VA's premises is that those who need help with their finances are a danger to themselves and others, what is done about firearms that are already stored in the home by themselves or other members of the household? If it's not the veteran's firearm, what happens to that firearm?
First, let me thank you and your family for your collective service. I may have to take that one for the record. That is not something that VA, whether VBA, VHA, or NCA, is responsible for.
And if you have 190,000 veterans who are currently under a fiduciary person status, why do you not know how many firearms have been confiscated in reference to Ms. Brownlee's question?
For clarification, it's 109, not to correct you, ma'am, but just want to make sure for the record it's accurately portrayed. It's 109,000, and about 63% of that are veterans. In our fiduciary program, we also have spouses. But with that, again, we report the incompetency numbers to DOJ, and there's no other engagement or involvement with us reporting or receiving information on numbers of weapons collected, taken back, et cetera.
So is there a HIPAA reason why you would not be able to collect that information, and don't you think that's valuable information to have?
I do believe that's in DOJ's lane. If Mr. Behrens has anything he'd like to add, please feel free, but I don't think that's VA's responsibility.
Before Mr. Behrens answered, have you requested that information? Have you sent a letter requesting the information for your records?
Not to my knowledge, no, ma'am.
Mr. Behrens?
Yeah, just to say that this is a government-wide reporting program administered by DOJ, so VA is one among all the federal agencies that comply, and I'm not aware that there's a general report out from DOJ on the actions taken.
I think that would be important information. I appreciate my colleague bringing up the question. Does the VA have any evidence that the current system in place for sending names to NICS list is actually working? And to put it simply, has there ever been a study done if it's actually providing any level of suicide prevention, i.e., if that weapon is confiscated and a veteran had suicidal ideology or dementia that led to suicide ideology, having read other testimony, do we have a correlation, a status? Are we preventing, because veteran suicide have gone up, not gone down?
So I would say that the studies that we cited in the testimony do reflect that the inability to access firearms does prevent suicides. And again, this is something that we are continuing, not just VBA, but VA as a whole, focusing on suicide prevention. We do cite some studies. I think some panel members may have some further information, but we do know, and I think it was in my oral statement, that 90% of suicide attempts with a firearm are successful, meaning there's a fatality. But when those weapons are removed, only 1 out of 5 that would have used a gun find an alternate means to commit suicide.
My time is almost over, but I did not see in those studies that there was a correlation. So yes, having access to a firearm, whether or not they were successful, my question is, in a person who's placed in a fiduciary status, what's that relationship? And I read the physician's testimony from Duke, but I didn't see that there's a correlation with fiduciary status and firearms and suicide. That's more the point, since we're talking about a fiduciary status. Thank you very much. I yield back.
Thank you, Doctor. Representative Budzinski, you are recognized for 5 minutes.
Thank you so much, Mr. Chairman, and good morning to everyone. And thank you to my colleagues in the committee for this, I think, really important discussion. I had the opportunity recently to visit the Veterans Hospital in St. Louis. I learned about all of the critical care they're providing to about 35,000 veterans that are on the Illinois side, which is the side of the river that I represent in central and southern Illinois. And a lot of those services are mental health services, and can certainly see the need after that visit of the greater need that we have to provide more mental health services for our veterans. I bring this up because of the statistics, the statistic that the suicide rate for veterans is 1.5 times higher than the general population. I also just want to point out that 71% of those suicides by veterans are happening by firearm. And so I just want to mention this obviously weighs really heavily on me personally as we're having this discussion about this topic. And I do believe we're all here today because we have a commitment to mental health, providing that to our veterans. And so I hope we can find some common sense, bipartisan solutions to ensure that both our veterans' rights and their health is protected. So I have a few questions related to how the VA evaluates the medical evidence that underpin the mental competency decisions made. And I'd like to start with you, Mr. Burke, if you don't mind. Mr. Burke, one of the arguments we've heard against the current process is that the determination that a veteran needs a fiduciary is based solely on their limitations to manage their finances. I think you've spoken a little bit about this already, but just to ask again, but in reality, there is a medical determination underlying that determination correct, is a question. And then just one quick follow-up, and I'll ask you to respond. Can you talk about the level of specificity in that medical evidence produced by the Comp and Pen exam?
Yes, to confirm your statement, it is medical information that is used to determine a finding or even a proposal, if you will, of incompetency. With respect to exams aren't the only avenue that we use. There could be other evidence submitted from a primary care physician, other entities. But with respect to the VA exams, CMP exams, there used to be a simple check block on the exam, yes or no, and we found that was insufficient, and so now the providers must detail the specific diagnosis that led to the check block of yes because of schizophrenia, yes because of PTSD, yes because of something else. And if I could just add one thing for clarification, and I think this is an important point when we talk about mental health, the mere presence of a mental health diagnosis does not lead to a finding of incompetency. And so when we talk about access to VHA and healthcare, we are telling folks through our comms, through our outreach, to access the benefits they deserve. The mere presence of a diagnosis isn't what leads. It's the finding of the inability to manage their funds independently or through contracting.
Okay, thank you for that point. And just to follow up, there's an additional charge that there's a lack of consistency as well between contract exam providers related to how the competency question on a DBQ is filled out. Can you speak to that as well?
I think with respect to both the training that is required for VHA and for our exam vendors, we will continuously look at ways to make sure that they are as aligned as possible. There's required training there now. The forms that we use, again, some improvements to the form to make sure we're drawing out more adequate, more complete findings. And in the medical disability exam space, it is something we continue to focus on increasing and improving quality and accuracy. And you have our commitment that we'll continue to do so.
Okay, thank you. I have a little bit more time, so I'd like to ask an additional question, Mr. Burke. What is the evidentiary standard that a VSR, our VSR, must adhere to when determining that a beneficiary may need a fiduciary? And then additionally, how are you training your claims raters to interpret and utilize that medical evidence?
So the determination of incompetency by our VSRs and RVSRs is based upon, and I have to stress, a definitive finding by a responsible medical authority or medical evidence that is clear, convincing, and leaves no doubt as to the person's inability to manage their affairs, or a court order finding the individual to be incompetent. And again, our employees that touch these claims, these cases, do get required training. And as was asked by the committee already, we will submit those training modalities as well.
Thank you, and I yield back.
Thank you. I recognize Dr. Murphy for 5 minutes.
Just give me a second. I might need a fiduciary myself. I want to applaud everybody here, everybody on the committee, in a totally apolitical, nonpartisan manner. Is everybody concerned about veteran suicide? I know there is, unanimity in that. Problem is in the manner in which we're attacking this. Mr. Burke, I have a line of questionings. I've just been sitting here writing out the PhD from Duke. I was just reading his report. I'm not sure he's ever seen a patient, but just reads off studies. So just going through the whole fiduciary process, is there just one single individual gets to check the box that says the person needs a fiduciary?
So sir, there's not. And so the way that the VBA processes a workload, there are numerous hands that touch the process, those that develop the claim, those that may go out and request a medical exam to elicit further information. It could be a rater that proposes a finding. And
all right, so I'm sorry, I don't want to go through that because I got other questions. So there's one person finally that has to check the box. I mean, there has to be.
There's one person, sir.
Is that automatically referred to a re-referral for evaluation just because you're taking away a person's constitutional rights? Is there any checks and balances to that final check of a box?
So the check and balance is actually the fact that before that final determination is made, the veteran and his or her representative get a proposed finding with a due process period.
All right.
Once that has expired, that decision is then appealable, but it is a final decision, and at that point...
But it takes an action of appealing rather than, because the veteran then has to jump through a bunch of different hoops from bureaucrats. So I was determined to be my mom's fiduciary when she got older and just couldn't handle her financial matters. It just wasn't there. It wasn't that she had any particular issues, but that made me her fiduciary. And so by definition, I'm her fiduciary. So if she were a veteran, wow, that would put her in a different category of an assumption of incompetence. Not incompetence, you just sometimes can't handle your matters. You brought up at one point, and Representative Brownlee asked you the question for evidence that this program had saved lives. And you mentioned that you'd have to get back to her. How long has the program been in effect?
With respect to providing information to NICS or the fiduciary program, we've had the fiduciary program for years.
For the one we're talking about, for taking away a person's Second Amendment rights.
So I know there was a NICS improvement in 2017. I'll ask Mr. Behrens if he has more.
The reason I say this is if we don't have information at this point that you have not here, not that you have right here, that this is saving lives, it's not that you do a program with the hope that would save lives, even though I guess we all really truly want to save lives. And it's not empiric evidence. You want factual evidence, objective evidence that this is going to save a life. And yes, I understand people with suicidal ideations and access to guns. Absolutely, I get that. I've been a surgeon, trauma surgeon, for 35 years, and I understand that part. But I just want us to be on the other side of making sure that those veterans have benefits. I will ask one thing, because you did mention PTSD as being one of the issues. Are you aware that there's a very, very good program, especially in my part of Eastern North Carolina, where it's where we take veterans out and it's hunting for veterans to help them with PTSD?
Yes, sir.
So how would, if somebody has PTSD how would they be able to participate in that program?
Well, as I cited in an earlier question, the mere diagnosis of a mental condition is not a bar to owning a firearm. There are different levels of severity with post-traumatic stress disorder and other mental conditions. It's only at the point where the medical evidence clearly and convincingly shows that the individual is unable to manage their funds independently that we refer to NICS.
Yeah, but managing funds, and as I said, I was my mom's fiduciary. Managing funds and having suicidal ideations are two absolute different things. Absolutely different. One is simple, basically you can't handle your affairs, and the other thing is you want to kill yourself. So you cannot make those equivalent, not by any means.
Simply complying with federal law. We have a requirement by law to submit those to NICS, and that is the crux of this conversation.
So is there any evidence that requiring a fiduciary has decreased suicide attempts?
There is evidence that access to firearms,
Sure.
right? But the fiduciary itself, the fiduciary program was not set up or established to remove, access to weapons. It's a byproduct of the requirement in the Brady Act. With respect to science and research, there is research that shows that limiting access to firearms does help us in preventing.
I'm really trying not to be belligerent. I really try, because I really want this issue solved with veteran suicides. It's tragic. I represent 1 out of 8 of my constituents as a veteran in my district. It's an absolute tragedy. It's also a tragedy in this country that 110,000 plus people now are dying from overdoses for drugs coming across our border, but I don't see us as a administration taking any issue with that. I appreciate your work. I can't say I agree with the premise on which you're working. With that, I'll yield back.
Thank you. I recognize Representative DeLuzio for 5 minutes.
Thank you, Mr. Chairman, and good morning. Thank you for being here. Before I proceed to my question, I want to offer one clarifying point for the record. There was some discussion of whether VA was alone in sharing or doing this kind of reporting to NICS under Brady, and my understanding is others who are doing this reporting include the Air Force, the Army, the Marine Corps, the Navy, the Defense Department, NCIS, HHS, FBI, ATF, and the Secret Service. So VA is not alone here. With that, I'll ask a question for all or each of you to weigh in on. I'm struck by how few veterans are using the avenues for relief or redress. And an open-ended question then to each of you, why do you think that is? I mean, it's a small percentage of the folks who are subject to these determinations. Why are we not seeing more, or should we be seeing more folks pursue these avenues? Is there something about advertising that they exist, or some other sort of information sharing with veterans in the program?
Yes, sir. Thank you for that question. The numbers are staggeringly low, and I believe it's a testament to the fact that the due process is clear, that there's a due process opportunity, that folks are afforded the opportunity to submit, medical evidence to the contrary of what we have considered. And again, the numbers are low, but I honestly do think it's because the process is clear. We also articulate in the due process with incompetency the specific impact on their ability to own firearms. It's pretty clearly explained. So I believe that the communication is clear and understood, and I believe that leads to the low number.
Just a clarifying question, gentlemen. Please feel free as well to weigh in if you'd like. When that determination is shared, and you mentioned the impact on firearm ownership, is there also information about the avenues of redress and relief provided to the veteran as well?
Yes, sir. Thank you for the question. Yes, we do address relief as part of the process, both in the final determination, and we also, in the appointment of a fiduciary, a field examiner goes out and physically meets with the beneficiary and discusses the impacts of the appointment of the fiduciary and what abilities exist for them.
Mr. Barron, is there anything you want to add?
No, I would just, again, reemphasize that we do conduct extensive outreach in terms of written and oral communication. So to the extent people are not taking advantage of the avenues of relief, I don't think it's for lack of communication.
So to put a finer point on it, the small number of folks who are pursuing this doesn't give you pause, because you're taking the view the VA is making it very clear at the outset of a determination that this is the path both for redress, but also that there is substantial process to get to that point.
Yes, I think that's fair, and we do give, with every decision VA gives, appellate rights, so not just the NICS relief program, but also to appeal the actual finding of incompetency.
Okay. Thank you. Mr. Chairman, I yield back.
Thank you very much. I will now recognize myself for 5 minutes. Just following the law isn't going to cut it. There's a lot of laws that aren't right. They just aren't right. And as my good friend, Ranker Takano, said, that Republicans do, they do pass bad legislation too. Contrary to what many of you guys might believe, I don't believe that only Democrats pass bad legislation. We've messed up some things ourselves. As a matter of fact, we just had an amendment that I proposed and was placed on the National Defense Authorization Act that basically, for the last decade or more, has authorized the United States military to pick up American citizens on American soil, whisk them off to a foreign land without charges, without counsel, and hold them for an indeterminate amount of time. That, by anybody's estimation, is completely unconstitutional. And to continue a process with which our veterans lose their Second Amendment rights because somebody might think that they are a danger, not a court, not a jury of their peers, but a bureaucrat sitting in an office somewhere has made that determination, is absolutely 100% wrong, and I really don't care what the law says. I really don't care what the law says. It's wrong. We have programs that show that it's not the simple act of owning a firearm that causes a problem and increases the likelihood that they're going to, a veteran who is suffering with PTSD is going to take their life. It's the time with which they think about it and then have access to that weapon. If the weapon's locked away, if it doesn't have the ammunition right next to it, the likelihood that they're going to take their life reduces dramatically. There's a very good program out. It's called Overwatch program that places time and distance between a veteran and their firearm to make sure that we can drive down the rates of suicide. Mr. Burke, with your previous statement, we've already established that veterans who need a fiduciary to manage their benefits are not always a danger to themselves or others. Current law treats them as being dangerous because they're unable to own a gun if they have a fiduciary. This is just simply false, a false premise. Do you think that a veteran who needs a fiduciary is mentally defective? Mr. Burke?
Well, I think the mere placement of somebody in our fiduciary program is based on the premise that they were found to be unable to manage their funds.
Mr. Burke, do you believe that a veteran who needs a fiduciary is mentally defective?
In most cases, a veteran that's been appointed a fiduciary does have mental impairment or a mental issue that has caused them to be unable to manage their funds.
That is just stunning to me that you would sit here and say that you think that a veteran who has a fiduciary is mentally defective. Under the current law, procedural due process is violated because a veteran is not afforded a proper pre-deprivation hearing before the imposition of firearm restrictions. I'm very concerned that the VA is treating veterans who need helping managing their money as criminals. Under this policy, anyone who uses the services of a firm to manage their books, a bookkeeping service, would be subject to surrendering their firearms and their Second Amendment rights. This is as ridiculous as it is dangerous. The Supreme Court found in Heller that the Second Amendment guarantees the individual right to possess and carry firearms in the case of confrontation, and in McDonald, the court established the Second Amendment to be a fundamental right applied equally to the federal government and the states. The way the VA is interpreting the statute is blatantly unconstitutional and an affront to the Supreme Court and the separation of powers. Mr. Burke, do you believe in due process?
I certainly do, yes, sir.
We're losing 21 veterans a day to suicide in this country. Are you concerned that veterans might be less willing to seek care at the VA knowing that it could result in them unfairly losing their Second Amendment rights?
I'm concerned anytime a veteran doesn't want to seek care or assistance, but I do not believe this process is a deterrent. I do not believe it's a deterrent, and that's why I'm here to
Well, Mr. Burke, I will tell you that I have had veterans come to me and declare that they are not seeking help because they are concerned about their Second Amendment rights being violated. Thank you very much.
And my point, sir, would be that we can together work
Mr.
on the
Burke, I've got
communications.
veterans who have quoted to me, okay? Quoted to me and come to me and said that they are concerned about their Second Amendment rights being violated, and that is why they are not seeking help. I will turn my time. Yeah, I will now recognize Representative Shurflis McCormick for 5 minutes questioning.
Thank you, Mr. Chairman. Mr. Burke, VA's authorities, as well as the processes and procedures used to determine mental incapacity and NICS reporting have been clarified, redefined, and codified since then, both in the NICS Improvement Amendments Act and the 21st Century Cures Act. Is that correct?
Yes, ma'am.
I will remind my colleagues that the 21st Century Cures Act was passed under a Republican-led House and Senate. So if VA's fiduciary program was so problematic, Congress could have chosen to reform it as opposed to validating it as we did then. My next question is for Secretary Burke. Is it safe to say that VBA is on firm legal footing to conduct the fiduciary program and are complying with the laws as written? Would you agree?
Yes, ma'am, and in consultation with our Office of General Counsel, we believe we are on firm footing. Yes, ma'am.
In fiscal year 2022, the VA provided fiduciary services to over 180,000 veterans. Of these veterans, there were a little over 14,000 referrals from the VA to the FBI's National Instant Criminal Background Check System, NICS. Of these 14,000 referrals to NICS, only 33 were appealed, and 11 beneficiaries were ultimately removed from NICS. Veterans make up less than 4% of the total NICS reporting, despite making up 6.4% of the United States population, meaning that veterans are underrepresented in the NICS. Mr. Farrell, how has the VA been estimating how many lives have been saved? And we asked you this question before, and we haven't got a clear answer. Is your office currently collecting the information to make this determination?
Ma'am, thank you for the question. No, we currently do not collect that information. We don't have insight as to whether or not, the fiduciary process and members within the fiduciary process are committing suicide. So we don't have that information readily available.
Thank you. As I mentioned earlier, only 33 were appealed out of the 14,000 veterans. How is the information made available to veterans that they have the rights to appeal?
So, ma'am, as part of the due process, as well as any final decision that VA renders, they get their appeal rights. I do want to point out that the numbers that you're referencing, the 33, those are ones that sought relief through the process, which is a low number. But also in FY22, there were almost 1,100 veterans who were previously found to be incompetent that were later converted to being competent. So again, lessening the number of folks that were on that next list.
And those people, were they appealing that right? The ones who you said who were made competent, did they appeal that right?
That could have been a combination of appealing or just mere submission of a new claim through one of those 6 avenues that the ranking member showed, whether it was a higher level review or some other submission of evidence. At some point, they were then later found to be competent to manage their funds.
Well, what I wanted to confirm was that all the veterans are aware of their right to appeal. Is that correct?
That is correct, yes, ma'am.
And only 33 appealed that right?
Only 33 sought relief through the relief avenue. The numbers that I don't have are how many may have done a formal appeal through the Board of Veterans Appeals or beyond.
Thank you so much. I yield back the balance of my time.
Thank you. I will now recognize Representative Ramirez for 5 minutes for questions.
Thank you. And I want to thank Chairman Bost and Ranking Member Takano for holding today's hearing. I also want to thank the witnesses who are with us today. For the last hour, you've heard from several of my colleagues on issues spanning from mental health to fiduciary issues. I should be able to pronounce it well. We've said it about 35 times in the last hour. But I want to take a moment to refocus on why we're here, why every single one of us here chose to be a member of the Veteran Affairs Committee, and why you sit here and the people that are sitting here listening. We are here for our veterans, our first-generation veterans, our veterans of color, and even some of us are here for our veterans who've been deported after risking their lives for the country we love. These veterans need our support, and the VA support in providing them with wraparound services and other resources they may need has to be our priority. We can go back and forth and blame game all day here. But let me just say what I think some of us have said here already. 121 suicides per day. 121 veterans commit suicide every single day. And if you do the math, that means in the hour that we've been debating and questioning and talking here and blaming each other, 5 veterans died. So I really want to make sure that we refocus ourselves and ask ourselves, what the heck are we doing as Congress, as the VA, and as every single organization who's committed in ensuring that our veterans have what they need so that they don't feel that life is such that they no longer can live? So I actually want to really focus on the mental health part here, because I think others will continue to talk about the other pieces. I want to ask you, Mr. Burke, what are the initiatives that the VA is spearheading to address the concerns with seeking mental health services for our veterans?
I think, honestly, ma'am, thank you for that question. This may be one that we come back with some further information from the VHA side of the organization. But I will tell you that every entity within VA is committed not just to suicide prevention, but making sure that we're communicating all rights, all avenues for access, for care, and for benefits. On the VHA side of the house, a very heavy focus, as you can imagine, on improving mental health. We have a suicide prevention office, obviously, and those folks are connected. It's a I hate to use a generic term, but a synergistic approach to us tackling mental health crisis and also making sure that we're putting a primary clinical focus on preventing veteran suicide. And we're happy to connect with you and members of the committee on more detailed information on what we're doing in that space, if that would be helpful.
And we know we're not doing certainly enough, right? I mean, enough is when we know that no veteran has to make that decision between life and death. So we have a lot of work to do. I do want to follow up and say, I mean, we know it's critical that we prioritize. We know it's critical that we do more. We know it's critical that we get into the nuance of what's happening in the supports and the claims. However, mental health and illness and disorders can also wax and wane over time. Mr. Burke, can you tell me what processes are in place for veterans to have the impact of their mental health issues reevaluated?
Certainly. With respect to the claims process, any veteran that's in receipt of compensation that has deteriorated or their condition has worsened, they have the opportunity to file a claim for an increase. They can come back and have another examination. We'll review additional evidence so that if they did have an increase or an exacerbation of their condition, that we could adjust the compensation rate and also ensure that's another touch point for us to make sure that they are in the VHA system, enrolled in health care, and seeking the appropriate attention there. But there is a claims process where we would collect new information, assess any potential increase in the severity of their condition, and then re-adjudicate a claim in that same fashion.
Thank you, Mr. Burke. Chairman, I yield back.
Thank you very much, Representative. I now recognize Representative Van Orden for 5 minutes questioning.
Thank you, Mr. Chairman. Mr. Burke, I've had, as of with Senior Chief Mike Day, 21 of my friends and colleagues commit suicide, veterans. So I'm going to say some things, and I want you to have that in the back of your mind at all times, please. I take this very seriously. It's very personal to me. Do you believe that our constitutional rights are granted by God?
I'm sorry, I'm here in a professional capacity, and my personal beliefs I won't bring into the hearing.
Okay. Well, do you believe that our constitutional rights are articulated in the Constitution of the United States?
I do.
Do you understand that our foundational documents say that our rights are derived from God?
I know the wording in the Constitution.
Okay,
Yes, sir.
great. So either you believe that our constitutional rights are granted to us by God and simply articulated in the Constitution, making them immutable, or you don't. Those two cannot exist in the same universe. Our rights are either immutable or they are not, which means if they're immutable, you can't take a pause on them. You can't have a cooling off period, for good or for bad, and oftentimes for bad. This is true. They are still our constitutional rights that are granted to us by God and articulated in the Constitution of the United States of America. And I believe you took an oath to support and defend that at one point, and I don't think that expired. It did not. So when the VA opposes this bill that would absolutely infringe on our constitutional rights, a well-regulated militia being necessary for the security of a free state, the rights for the people to keep and bear arms shall not be infringed, this will infringe on that. So either your oath to support and defend the Constitution of the United States of America expired, or you're in error in supporting this or opposing this bill. That is a factual statement. Okay, I want you to rethink this policy.
May I respond to that?
Of course you can. I'd love you to, Mr.
I will just say, I take exception to anyone, member of Congress or not, questioning my oath that I took.
I'm not.
My entire life, my entire adult life, has either been in uniform or serving those that were in uniform.
I get it.
I'm simply in a position where we are complying with the law, and we always commit to work with Congress on improving legislation in the matter of law. But for the record, I take it seriously as well.
Good. I'm not saying you don't, and I'm not impugning your reputation, sir. I'm just saying that these two things, by definition, cannot exist in the same universe. They're incompatible, and we have to do things in a way that we look at things globally. And again, the reason I told you I've had so many of my friends commit suicide, so that you know that I'm saying this from a place where I want that to stop. But we also have to balance our individual rights that are granted by God and articulated in the Constitution with sometimes these most horrible of things. I've held my friends' children's hands at their funeral because their father committed suicide, and I've cried with their widows. So this is real. But we have to make sure that we don't lose our freedoms trying to protect them. Can we agree on that, sir?
Yes, sir.
Thanks, man. Okay, going to this other. Mr. Pelt's Accrued Veterans Benefits Act. You oppose this bill, and why is that again? I mean, I read your testimony. I'd just like you to do the Reader's Digest. Have 1 minute and 7 seconds.
Yes, sir. There are just a couple things that it creates some complexities, different discontinuation dates.
Yep.
It not only makes it complicated for our veterans because of different dates and different change in benefits, impacts the complexity for the processing for our employees. And as you know, quality of processing is keenly important. And it also, the complexity with the different dates and the nuances also make it hard for things like technology advancements, automation, and speedy delivery of benefits.
So,
again,
sir,
happy to work with Congress on some technical assistance, but as written, we oppose for those reasons.
okay, but in the aggregate, if you had your choice to err on the side of the veteran or not, would this be more beneficial financially to the veteran or not?
Parts of it would be, other parts would actually be a detriment. There are some parts where it would negatively impact a surviving spouse and remove a payment, and those are the things that we're concerned about.
Okay, then I seek a little bit more clarity in your testimony about this. Is that good? All right, with that, I yield back, Mr. Chairman.
Thank you, Representative, and I'll now recognize the ranker briefly for a follow-up question or two that he had.
Well, thank you, Chairman Rosendale. I just want to briefly just say that the Constitution begins with we, the people. The men, and mostly men, wrote the Constitution, came together not thinking they were channeling God, but were thinking that in a practical way they were trying to unite colonies. And the Bill of Rights was added later. and that they think of human beings neither as God nor devil, but somewhere in between. And that's why we needed the Constitution, to have power and ambition check ambition. And so it's a very practical document. The Declaration of Independence, of course, does claim to channel God in terms of endowed by their creator, a sense of a system, a belief in the natural rights. But let's turn back to, I just want to get at a couple of things. Chairman, you said that you admired the program that puts some distance, that separating ammunition from the weapons, and that you talk about a program that could, Urban Watch. Sounds very much like safe storage and lethal means training, that counseling veterans about how to safely store firearms and lethal means training, that this could save lives and could prevent suicides. And I hope that you might work with us to see that that policy gets implemented, because it sounds very much what you were talking about. Mr. Burke, I just want to confirm one thing, and the chairman was very concerned about the veterans that come to him talking about their fear of having their guns taken away, because they don't trust the VA on that. Again, I want to hear this on record, does the Veterans Health Administration report any veteran to NICS who are getting treated for mental health or any other condition?
No, sir, the VHA does not communicate any information to NICS. The only entity that provides information is VBA direct to NICS. VHA does not.
Now, I have no doubt that people came to the chairman with this concern because there is a perception and a belief out there. Is that your understanding? There's a perception and belief among veterans that the VHA will turn them over to NICS?
Absolutely, and I do appreciate the members that communicate directly with each member of this committee. What I would say is, our willingness to partner to make sure that everybody that has communication and contact with veterans has the right message. If we can partner together and communicate that the mere diagnosis of a condition, entry into the medical centers for treatment does not necessitate an automatic removal of weapons, we're willing to partner further on strengthening that communication so no veteran feels as though he or she cannot go for treatment or care for fear of losing their weapon.
So there is a perception problem, there is misinformation and disinformation out there, which is insidiously misleading our veterans into thinking that if they go to the VA to get treated for mental health or any other condition, that could lead to their inability to buy firearms because they've been misled into thinking that the VHA will report them to NICS. And I want to, just for the record, again, that is not true. Is that right?
You are correct. I want to clarify for any veteran that watches this hearing or reviews the testimony later, the transcript, VHA, the Veterans Health Administration, does not provide NICS with any information, and any veteran that feels that he or she needs assistance or treatment from the VA should seek such.
In the time I have remaining, I just want to address this issue. I mean, my Republican colleagues believe that about a pre-deprivation hearing by a judge, a federal judge. I don't believe that that's necessary, that it is important that we have a fiduciary program, that we do have 6 layers of appeals where they can seek relief from having their from the putting on the NICS list. Effectively, he said, would lengthen the process if they brought in a federal judge or some level of a judicial figure. That would effectively really impair VA's ability to put anyone on this list. Is that right?
That is correct, sir, and I do believe that the process as written would prevent us from potentially saving a life, and so by elongating the process, that is the point I was making earlier.
The process as defined by the Republican bill.
That's correct, yes,
Thank
sir.
you. I yield back.
Thank you, Ranker Takano. I will now recognize Representative Ramirez momentarily.
Thank you, Mr. Chairman. I wanted to correct the figure that I gave in my remarks. Fortunately, when we were talking about the number of suicides per day. The information that I was given to me was incorrect. It's actually 17 per day, so I'd like to make sure that we correct that for the record. Either way, too many. Thank you.
Thank you very much for that correction. And I would just like to say that while the VA may not be the ones who actually take a gun or report to NICS, you certainly are the conduit with which it happens, and it gives you plausible deniability, being able to transfer that information off to someone else. You start the chain of events that cause this to take place. So that's what it boils down to. With that, I would like to thank Mr. Burke, Mr. Friel, Mr. Behrens for testifying today, and you are excused from the witness table. Once they are out of there, I would like to invite the second panel to the witness table, if you want to prepare yourselves. Before we introduce the second round of witnesses, the second panel, I would like to recognize Representative Stefanik for 5 minutes to comment on your bill.
Thank you so much, Chairman Rosendale, and thank you to Ranking Member Takano for the opportunity to join the Veterans Affairs Committee today for this critically important legislative hearing. Today's hearing is critical for veterans across my district in upstate New York and the North Country, but especially so for the Peltz family from Queensbury, New York. Ernest Pelt proudly served in the U.S. Navy from 1942 to 1946. During World War II, Mr. Peltz bravely protected our freedom in the Pacific Theater on the island of Guam. During the final chapter of his life, he lived in Queensbury, New York, to be close to his son, Charles. While living there, his health tragically began to decline, and the Warren County Veterans Services Office assisted Mr. Peltz with his application for pension benefit, for which he was approved on December 16, 2019. My office was proud to help with that effort in the form of casework and constituent services. Mr. Peltz passed away shortly thereafter on January 1st, 2020. January 1st is New Year's Day. On New Year's Eve, I was in contact with the Peltz family, with Charles Peltz, that his father, as he was on his deathbed, was so concerned about the VA not processing his claim. And I told the Peltz family we would work to make this right. Due to a processing error at the Department of Veterans Affairs, the approved funds were not deposited into Mr. Peltz's account until 7 days after his death, on January 7th, 2020. The VA's erroneous delay in the disbursement of Mr. Peltz's benefits resulted in the VA clawing back those funds from Mr. Peltz's account, despite the fact that the VA approved his benefit while he was alive. This is unacceptable. Mr. Peltz's distinguished service to our nation came in a great national time of need, and he worked hard to serve this country to earn this benefit, a benefit he was owed. These funds should have been passed down to his family through his estate. Again, on this gentleman, on this hero's deathbed, he was very concerned about the VA malfeasance and the red tape. A family mourning the loss of a loved veteran is a burden enough. The VA must work to ease these burdens, not increase them, as they did with the Peltz family. I have worked for years with the Peltz family, our great veteran service organizations that are before us today, and the VA, as well as members of this committee, on crafting this legislation to ensure no other family has to endure what they went through when World War II veteran and hero Ernest Pelt passed away. My bipartisan bill, named in honor of Ernest Pelt, eliminates the burden on surviving families by ensuring that veterans receive their already approved pension benefits for the month at their death, and prohibits the VA from clawing back these funds after they are approved, as they did in the case of Mr. Ernest Pelt. I want to thank the service organizations that are here today for your support of this legislation. I want to thank the committee for working with us on this legislation, as well as my colleagues across the aisle who have worked to support this legislation as well, and I yield back.
Thank you very much, Representative Stefanik. It's very important legislation. We're glad to have it in front of us. I'd like now to welcome Dr. Jeffrey Swanson, professor in psychiatry and behavioral sciences from Duke University School of Medicine, Mr. Bob Carey, chairman of the National Defense Committee, Mr. Cole Lyle, executive director of Mission Roll Call, and Ms. Christina Keenan, deputy director of National Legislative Services for Veterans of Foreign Wars of the United States. I appreciate all of you being here today. I ask the witnesses to please stand and raise your right hand. Do you solemnly swear that the testimony you are about to provide is the truth, the whole truth, and nothing but the truth? Thank you very much, and let the record reflect that the witnesses have answered in the affirmative. Dr. Swanson, you are now recognized for 5 minutes for your testimony.
A challenging policy dilemma underlies arguments for and against the proposed Veterans Second Amendment Protection Act. On the one hand, private ownership of firearms is a constitutionally protected individual right that is especially cherished by many U.S. military veterans. As a group, veterans are twice as likely to own a firearm as the general population. On the other hand, veterans are dying every single day by suicide with firearms, in numbers exceeding the toll of those who perished in war. Each is a preventable tragedy of immense human cost. Suicide is the second leading cause of death in veterans, who are 57% more likely to die by suicide than non-veteran adults, and veterans' greater access to firearms plays a key role in their increased risk of suicide. Veterans are far more likely than non-veterans to use guns, the most lethal weapon in suicide attempts. Approximately 1 in 5 suicides in the United States is a military veteran. So a key policy question is, how do we find the right balance between mitigating risk and upholding rights in designing and implementing legal restrictions of veterans' access to firearms? No firearm restriction policy is perfect, and there will always be errors made in its application to individuals, false positives and false negatives. Is it better for the law to err on the side of preserving the Second Amendment right for more veterans, even if it means that some will die preventable deaths? Or is it better to err on the side of saving more lives at the cost of restricting the gun rights of some veterans who would not have died by suicide anyway? Wherever the lines are drawn to mark out a category of people deemed sufficiently risky to override their Second Amendment right, we should aspire to provide due process protections and opportunities for appeal that are sufficiently robust to offer a meaningful and not overly burdensome chance for individuals to contest their deprivation in an adjudicative process, either by judicial authority or an administrative officer acting in that capacity. And on that score, the current policy might be seen as a work in progress. It could be improved. We cannot know precisely each individual's likelihood of harming others or self with a gun. We know that some categories of people are generally associated with relatively higher risk. One such category comprises VA beneficiaries found incompetent to manage their VA affairs. The statistical evidence for this is indirect. It would be most informative to bring direct evidence to bear by studying the actual population of veterans with fiduciaries, to quantify their concentration of risk factors for dangerous behavior, and examine their specific suicide mortality rate with and without firearm involvement. Such a study has yet to be conducted. In the meantime, our research group carried out a study designed to estimate risk of suicidal behavior and interpersonal violence in veterans who are most likely to be assigned a fiduciary. We analyzed data on 3,200 post-deployment veterans from the Iraq and Afghanistan war era. We constructed 3 separate indicators of need for a fiduciary in these data, based on cognitive performance, substance use disorder, and acute psychopathology, and we found that all 3 of these proxies for a fiduciary assignment were statistically significantly correlated with suicidal symptoms and interpersonal violence. This third indicator identified a small group of veterans who were, on average, 8 times more likely than other veterans to have suicidal symptoms and to have engaged in violence. In summary, our research provided evidence consistent with the public safety rationale for the policy of fiduciary NICS reporting. However, I have also concluded that a somewhat analogous civilian policy of reporting incompetent Social Security beneficiaries to the next was not warranted. It was overbroad, not supported by evidence, and lacked due process. Policies that restrict access to firearms for people who pose a high risk of harming others or themselves can and do save lives. But in this country, such policies need to find the right balance between mitigating risk and preserving rights. And the current VA policy of reporting to the NICS the names of veterans who are assigned fiduciaries is not perfect. It could be improved, especially if guided by more research. We cannot know precisely each individual's likelihood of harming others or self with a gun. We know that some categories of people are generally associated with relatively higher risk, and one such category comprises VA beneficiaries found incompetent to manage their VA benefits. The statistical evidence for this is indirect. In closing, I have a personal interest in this as well. My late father, a gun owner who served honorably in the United States Navy in the 1940s, was deemed incompetent by the VA toward the end of his life. I was his fiduciary, and I understood clearly why he should not have access to guns. I have also lost 3 members of my extended family to gun-related suicides, and each of them was a preventable tragedy that caused immense suffering for their families and friends. And I'm happy to take your questions and provide further assistance to the committee.
Thank you, Dr. Swanson. Mr. Carney, you're now recognized for 5 minutes for your opening statement.
Chairman Boss, Representative Takano, members of the committee, thank you very much for having me here today. I'm Bob Carey of the National Defense Committee. I'm going to probably be somewhat contrarian here, but I believe there are no constitutional rights to due process or to ownership of guns. These rights are inalienable and pre-exist the Constitution. The 2nd, 5th, and 14th Amendments don't grant those rights. They restrain the federal government from impinging upon those rights. And that is what is not being provided by the current fiduciary program. The fiduciary program is effectively a gun control program. It does not matter who takes away the gun rights, whether VA or DOJ takes away the right. The previous VA officials admitted that the program saves lives, and from a policy perspective, they want it to by controlling access to guns. And when we talk about the VHA versus VBA, the Veterans Benefit Administration, as the previous official said, use VHA data to determine whether someone needs to go into the fiduciary program, and then the VBA uses that data to make the fiduciary determination, and then the VBA justifies reporting to the DOJ based upon that Veterans Health Administration data. The VA fiduciary program does not provide adequate due process. It does not meet the standards of the ATF regulations for mental defective. There is a presumption of incompetency. The burden of proof is on the veteran to prove their competency, not upon the VA to prove the veteran's incompetency. And there is no judicial oversight or requirement, as there is with the Social Security Administration's incompetency process. That does require court action. There is no statistical correlation between gun access restrictions and reductions in suicide or mass shootings. As I detail in my report, in my written testimony, the RAND study did an extensive meta-analysis of all these different gun safety studies and found no statistical correlation, inconclusive evidence that either restricting access to guns because of mental health issues or emergency protective regulatory orders, red flag laws, reduce suicides or mass shootings. As I detail in my testimony, my written testimony, the VA itself presented at the VA DoD Suicide Prevention Conference of 2019 an extensive study of about 7,300 suicide risk models, and found that there is no capacity to predict that activity. And in fact, when you have that it was able to positively predict 1% of the suicides, but that for every one suicide that would be properly predicted, 842 false positives would be predicted, but they would still be under the same fiduciary rule. And then the American Psychological Association said there is no statistical evidence that links any type of psychological illness to mass shootings or to gun violence. And then the National Academy of Sciences study that I referenced also said that 35% of the veterans that were surveyed said they did not believe that their gun rights would be protected if they went to the VA. It does not matter, whether the VA is the one that takes away your gun rights or the Department of Justice. Your gun rights get taken away. So what are our recommendations? We do not believe that VA will ever change on this. It's going to have to be legislatively mandated if we're going to provide those due process rights, not only on the gun rights issue, but on the underlying issue of due process rights for managing your own finances and managing your own health care. We need to place the burden of proof on the VA to prove incompetency, not upon the veteran to prove their competency. We need to refer positive decisions by the VA to the Court of Veterans Appeals to give a judicial oversight. And we need to de-link the fiduciary program from reporting to the NICS database. As far as the Pelts Act, we do support that. Given some of the concerns raised, which I think are legitimate, about differentiation between different types of final benefits being provided, my recommendation is you standardize it across the board and just expand the Pelts Act to standardize it across the board. I look forward to your questions.
Thank you, Chairman Bost, Ranking Member Takano, and members of the committee. On behalf of Mission Roll Call, a national nonpartisan program, and the roughly 1.4 million veterans and supporters who have opted into our digital advocacy network, thank you for the opportunity to provide their feedback through our remarks on pending legislation. In 2022, Mission Roll Call sent out 30 policy-based polls with approximately 159,000 responses and spoke to 5,000 veterans in person around the country seeking the ground truth. Based on those interactions, MRC's three main priorities are veteran suicide prevention, access to health care and benefits, and amplification of voices of traditionally underserved populations. As these topics are broad and complicated to tackle, MRC continuously polls veterans and supporters on a wide range of topics, usually when Congress, the VA, or the White House releases policy that may directly or tangentially affect veterans across the United States, or at the suggestion of a member of Congress or committee that wishes to ascertain the veteran community's opinion on a particular topic. I welcome all members of this committee to use MRC as a resource as you seek to craft thoughtful legislation with respect to veteran issues. MRC supports H.R. 705, the Veterans Second Amendment Protection Act, as a necessity to ensure veterans receive the same due process as the average American whose rights they serve to protect. Currently, the VA is the only federal agency to refer veterans to the FBI's NICS database following a determination by agency officials, not a court, that the veteran cannot manage their own VA benefits. Under the Brady Act of '93, Congress authorized the DOJ to receive data from government agencies on any person whose receipt or possession of firearms violated the Gun Control Act of 1968. As part of the implementation process, the VA defined a mentally incompetent person as, quote, one who because of injury or disease lacks the mental capacity to contract or to manage his or her own affairs, including of disbursement of funds without limitation, end quote. This determination does not include any consideration of whether the person is considered to have a propensity for violence or is considered a threat to themselves or others. Thus, for example, a veteran who during the determination process for disability compensation indicates that because of a traumatic brain injury, they are experiencing short-term memory loss, which affects their ability to manage their finances, they could be determined to be mentally incompetent, even if there is no evidence that this veteran's condition would impair their ability to safely own or handle a firearm, or that they are a threat to themselves or others. Since 1998, VA has provided records to the FBI for inclusion in the NICS index on beneficiaries for whom a fiduciary has been appointed by VA on his or her behalf. The appointment of a fiduciary is based on a VA determination that they are mentally incompetent under the previously mentioned definition in VA regulations. As of December 2020, federal agencies have contributed 263,225 records to NICS, of which the VA contributed 98.1% of the total number. This incongruity in the implementation of the law between the VA and other federal agencies unfairly prejudices veterans by stigmatizing those who are challenged with service-related healthcare issues as inherently dangerous to others, when in fact, several studies and data from the U.S. Bureau of Justice Statistics show no evidence that military veterans, including those who saw combat, are more prone to lethal violence than the general population. Furthermore, veterans convicted of violent gun-related crimes in the federal prison system accounted for less than 1% of the entire federal prison population and were almost 7% less likely to be incarcerated for a gun-related charge than the civilian population, per the United States Sentencing Commission. Veterans across this country know that, despite challenges with a few bad apples, our community is one of service that abides by the laws they were sworn to protect, and in fact is less dangerous and less prone to extremism, as some have argued. These points are likely why, when asked about the VA's current policy of referral to NICS per the Brady Act in a recent MRC poll, 83% of 9,968 veterans said Congress should change the law. Finally, there are those who would use the alarming rate of veteran suicide to justify a lower standard of referral to NICS, citing access to guns as a prime driver of veteran suicide rates. While data from the U.S. Department of Veterans Affairs asserts veterans who kill themselves are more likely to use a firearm, they only track declared suicides and fail to account for self-injury mortality. Per recent studies, over 80% of self-injury mortalities are overdose deaths. Accordingly, a more upstream approach to tackle veteran suicide, rather than focusing on the lethal means of carrying out the deed, would serve to prevent far more veteran suicide deaths. This is in line with the wishes of many veterans throughout the nation who are begging the VA to approach suicide prevention in a more holistic way, looking proactively instead of reactively at the issue. The current status quo of fiduciary determination and referral to NICS for veterans simply undermines the spirit of justice veterans fought to defend, taking away a constitutionally enumerated right by a bureaucratic determination rather than a court order. The results of MRC's poll were clear. Congress should pass legislation protecting veterans' rights. Chairman Bost, Ranking Member Takano, this concludes my testimony, and I'm happy to answer any questions you or other committee members may have.
Thank you, Mr. Lyle. Ms. Keenan, you are now recognized for 5 minutes.
Chairman Bost, Ranking Member Takano, and members of the committee, on behalf of the men and women of the Veterans of Foreign Wars of the United States and its auxiliary, thank you for the opportunity to provide our remarks on legislation pending before this committee. The VFW supports the Ernest Pelt Accrued Veterans Benefits Act, which would ensure VA pension benefits are paid out for the entire month when a veteran passes away. By receiving the full month of death payment, survivors would be able to better manage the financial hardships that come with a veteran's passing. The VFW also supports the Veterans Second Amendment Protection Act. This would establish due process for veterans with fiduciaries before VA refers them to the National Instant Criminal Background Check System, or NICS. The Department of Veterans Affairs sends the names of all veterans in their system with fiduciaries to NICS, and once referred, veterans are prohibited from purchasing, possessing, receiving, or transporting firearms. The fact is, VA is the only federal entity that has made substantial referrals to NICS. Why? It comes down to definitions. The Brady Handgun Violence Prevention Act of 1993 established that an individual adjudicated as a mental defective or who is committed to a mental institution may not own a firearm. The ATF further explains that this would include persons determined by a court, board, or commission to be a danger to themselves or others, or lacks the mental capacity to contract or manage his own affairs. The VA has interpreted the law even broader within its own regulations. It defines a mentally incompetent person to be one who, because of injury or disease, lacks the mental capacity to contract or manage his or her own affairs, including disbursement of funds without limitation. The VA's interpretation concerns the VFW because once a veteran is determined to need a fiduciary, no other screenings or medical assessments are conducted. These would be key to learning if the veteran is a danger to themselves or others, or indeed lacks the mental capacity to manage aspects of their lives besides their finances. For example, take a veteran with severe PTSD who experiences debilitating anxiety when trying to go through their bills. While they may require assistance to ensure their bills are looked at and paid on time, the veteran may be capable of taking care of other aspects of their life and poses no threat to themselves or others. Without due process, veterans with fiduciaries may be wrongly referred to NICS, infringing on their Second Amendment rights. Furthermore, VA's practice of referring all veterans with fiduciaries to NICS has had a negative impact on veteran trust. Our members regularly tell us that they refuse to seek VA mental health care because they fear their firearms will be taken away. This has created a significant stigma around mental health and has created barriers to care. This perception is difficult to change. The VFW encourages veterans to use their earned VA health care, including the world-class veteran-specific mental health services that VA provides. The VFW has also been involved in numerous efforts to reduce veteran suicide, including urging veterans in distress to consider using trigger locks or to temporarily give their firearms to a trusted friend to lessen the ease of using a firearm to harm themselves or others. The VFW also believes in looking at the economic factors that veterans face that can also put them at a risk for death by suicide. As we know, suicide is not solely a mental health or firearm issue. Lastly, though the VFW estimates that the problem surrounding fiduciaries likely affects a small number of veterans, we argue that every veteran deserves protection of their constitutional rights. Chairman Bost, Ranking Member Takano, this concludes my testimony. I'm prepared to take any questions you or the committee may have. Thank you.
Thank you, and I would now like to go to questions. I will recognize myself for 5 minutes. Now, this is for anyone on the panel, or all of you on the panel. Do you believe an American citizen is due their day in court before they lose a constitutional right?
Yes.
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 This is for the whole panel as well. Do you believe that veterans fought to defend those constitutional rights?
Absolutely.
Yes.
Yes.
Do you believe that veterans have been trained on how to handle a gun?
Yes.
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 Do you think it's logical to assume that veterans are better suited to handle a gun safely compared to the average citizen?
Yes.
Probably.
Okay, given that, do you think a veteran, at the very minimum, should have the same due process rights as every other American before they lose their constitutional right?
Yes.
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 Okay. With that being said, remember what we're trying to do here. What we're trying to do is make sure that it is not, regardless of what was said earlier, a bureaucrat, but a court of law that makes a decision to remove a constitutional right based on evidence that is found. Ms. Keenan, would you please elaborate on the consequences of the VA current practices of reporting veterans with a fiduciary to the NICS list has had with respect to perpetuate the broken veterans stigma?
Thank you, Chairman, for that question. The current VA process of referring veterans to the NICS list has created mistrust with veterans in regards to VA mental health care. And when we talk about suicide prevention, there are risks to veterans not seeking mental health care. So we want to consider that as a factor. We want to encourage veterans to come to VA for their mental health care, and if that trust is broken, then we also look at this as a suicide marker. Thank you.
Thank you. Mr. Carey, are you familiar with the research done by Dr. Swanson, and do you have any comments with that?
Well, yeah, I did read over I appreciate him attaching the report, the Informing Federal Policy on Firearm Restrictions. And I think there's some, methodological issues here that may overestimate the amount of positive flags. For the proxy regarding illicit drug use, it's any diagnosis of drug abuse except alcohol. In the substance use disorder cases that I've seen, not only is it comorbid to have alcohol and illicit drug abuse, but alcohol itself is pretty darn bad. And in the example that he used in his study, in the case of Clennon v. Shinseki, it was about cannabis. And basically, the court was deciding that the fiduciary ruling was adequate because the continued cannabis use is detrimental to Mr. Clennon's further progress and needs to be stopped. Now, at the same time, this committee, the Senate Committee, Senate Veterans Affairs Committee, have been discussing how to expand the availability of cannabis for veterans. And so where does this stand? On the IQ-based, there is for all these proxies, 74 were flagged as hitting the IQ proxy, but only 14 of them were flagged as having a suicide risk. 72 were flagged as hitting the substance abuse proxy, but only 14 of them were flagged as suicide risks. Of the 294 who reported violent behavior, only 13 of the IQ flags, 18 of the substance abuse flags, and 39 of the severe mental illness flags were classified to be at risk of fiduciary need. And Dr. Swanson goes through and points out a number of limitations to his studies, such that self-reported suicidal ideation and troubling controlling violent behavior do not directly assess the risk of misusing a firearm. And the public safety case for a putative risk-based reporting to NICS is weaker for veterans identified solely by the illicit drug abuse proxy or intellectual impairment. So I think this lines up with the VA study that I talk about in my report, that in my testimony that goes on about how there's really no statistically significant predictive methodologies.
Thank you. My time has expired. Ranking Member, I'm recognized for 5 minutes.
Thank you, Mr. Chairman. Dr. Swanson, recognizing that no system is perfect, does your research lead you to believe the fiduciary assignment process is a sufficient proxy for a direct determination of dangerousness as it is currently constituted?
I think it's the best we have available now, and I think we need to be careful not to make the perfect the enemy of the good enough as we try to find our way, perhaps, to a better policy in the future. As I mentioned in my testimony, the evidence for the fiduciary being correlated with risk is indirect. It would be better if we had a direct study of the individuals who have been assigned fiduciaries, and I would be eager to conduct such a study in collaboration with VA. But as for now, the problem we're addressing is that all of the risk factors for suicide and for violence are nonspecific, and they're going to apply to more people who are not going to do the thing we're trying to prevent. Unfortunately, when we balance probability of a poor outcome, we have to think about the consequence we're talking about. So if it's going to be catastrophic, somebody's going to die, someone's life is going to be cut short with loved ones left behind, maybe it's important to have a probability that's going to try to save that life.
Well, in terms of your pragmatic observation, if I could restate it, the result of a false positive in this case is that a veteran won't be able to buy a gun to put on the NICS list. The result of a false negative is that a veteran dies, potentially. And you're conceding that we have indirect evidence, and you're saying that you would think that we should pursue studies that offer a more direct understanding. And I would agree with you, and I would say that the committee should not rush into a bifurcation or separation of the determination process and the NICS list, but that we should hold steady for the sake of caution, the practical result of which would be potentially saving veterans' lives. We don't know that for sure with absolute certainty. But perhaps this committee should be interested in pursuing and urging VA or requiring VA or mandating VA to do more studies, to get more information, to look at the data more carefully. What do we know currently from the data we do have and the analysis we do have? What do we know about the population of veterans, of beneficiaries assigned a fiduciary with respect to their increased risk for death by suicide?
Again, we don't have direct evidence of the veterans who have been assigned fiduciaries because we haven't studied those individuals directly. What we can do is make an inference based on people who look like them, other veterans. And there, in terms of relative risk, if we think about suicidal ideation in the first two proxies we talked about is probably about twice as high, and in the third one with regard to acute psychopathology, which is having a disorder like schizophrenia that impairs the brain's ability to reason or to regulate mood in the case of bipolar disorder. In addition to that, having been hospitalized as a criterion, and having active symptoms. And that, as in terms of relative risk, was 8 times more likely to have suicidal ideation or violent behavior. So again, it's relative risk, and we have to keep that in mind in terms of balancing out the efforts to mitigate risk and to uphold the right that we're talking about, because there is a constitutional right at stake.
So as I was suggested in my statement, would it not be more prudent to wait until we had additional information before plowing forward with the reforms my colleagues are proposing in the bill we're considering today?
I think so. I think in the meantime, it seems unwise to me to simply scrap the reporting policy that's been in place for decades without having something better to put in its place.
So, thank you. Before yielding back, I just want to say that, the rights, if you believe that they pre-existed the Constitution, that the Constitution attempts to preserve, was a practical attempt by very practical men, objected to by Abigail Adams, who felt that John Adams had forgotten about the ladies, but that ultimately they were practical, but the Constitution itself had some very serious flaws and serious compromises within it. But nevertheless, I think in the spirit of the pragmatism of our founding fathers that we should err on the side of caution in this case and practicality. I yield back.
Thank you very much. I'll now recognize Representative Self for 5 minutes of questioning.
I think I heard one of you in your testimony say we need to normalize under the second bill that we're normalize when death happens, normalize all of that, and I think that's a pretty good solution. I want to go back to the Bill of Rights, though, just real simply, and it won't take long. There is a preamble to the Bill of Rights, not the preamble to the Constitution itself, but a preamble to the Bill of Rights. And the Constitution to the Bill of Rights is very clear that the states wanted another set of amendments, the set of amendments that would further constrain the federal government. It's very clear in the preamble that this is not, they were being very pragmatic, that the Constitution itself, the articles themselves in the body of the Constitution, did not go far enough in limiting the federal government. And that's why we have the first 10 amendments to the Constitution. They set that high bar, and I appreciate the testimony of all of you here. And I'm going to leave it at that. There's not a question here. I just want to point out that the preamble to the Bill of Rights is very important to tell us why we have the first 10 amendments to the Constitution. Thank you. I yield back.
Thank you very much, Representative Self, and I will now recognize Representative Van Orden for 5 minutes of questioning.
Thank you, Mr. Chairman. Were you here earlier, sir, Mr. Swanson?
Was I here?
Were you here
Yes.
for the first panel? Okay, so I don't have to go through the whole thing that Mr. Takano is referring to. It is very easy to legislate the removal of an inanimate object. I've been carrying weapons my entire adult life, and it's very easy to legislate removing that. It is nearly impossible to legislate the healing of a man's soul. And that's the core issue here. It's not the weapon, it's the soul of the person that's been injured by combat, and I have multiple combat tours. So what you're doing, sir, is chasing a symptom, and you're not looking at the root cause. I understand you volunteered to study this again. I read your resume. It's incredibly impressive and tragic at the same time. I'm very sorry about your family's history. It's just terrible. Your academic record is incredibly impressive. And it just seems like you want to do more of the same. Study, 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 study. On a philosophical level, the Constitution of the United States has a provision that's written into it that allows you to change the Constitution if you feel that it's been in error or it needs addition. That's the amendment process. The 18th Amendment was passed that prohibited the sale of alcohol in the United States of America. It was in play for like 3 years, and they realized it was a terrible mistake because it had increased organized crime, and it was repealed. The original error that Mr. Takano is referring to, it wasn't just an error, it's the original sin of the United States of America. The compromise was made to count human beings as 2/3 of one person if they had more melanin in their skin than other people. And that was horrible. The finest, in my opinion, amendment that has ever passed in the United States of America is the 13th, which got rid of slavery and indentured servitude. So in the spirit of the 18th and the 21st Amendment, which repealed it, are you calling for the repeal of the Second Amendment?
I am not. I'm prepared to accept the way the Supreme Court has interpreted the Second Amendment and to try to work within the exception in Justice Scalia's statement in Heller that the right is not unlimited. And so it
That's
falls
correct.
to
In
us
the
to
reading
try to-
law, in the book Reading Law, Antonin Scalia goes through the developmental process of the Second Amendment, and I think that you're misinterpreting what he's saying. So now listen to me here. What we're doing is we are subverting the Second Amendment. The Veterans Administration does not have the authority to remove constitutional rights now or ever. This body, including my Democrat colleagues, are the only body that are chartered by our Constitution that can change it. You are not. Neither is he. You can't do that. And you're actively, willfully, and knowingly subverting the Constitution of the United States of America, and that will not stand with this body, sir. So either you amend the Constitution, which is incredibly difficult on purpose, so you can't willy-nilly change these things. It takes a very deliberative and hard-fought process. We watched the movie Lincoln last night as a body, and it's fantastic. It was a 2-month period of time about the ratification of the 13th Amendment, which freed men and helped correct the original sin in this country. And it was 20 Democrats voted for that. And if they had not, it would not have passed. So either you call for the repeal of the Second Amendment or you stop doing this. And you stop doing this. Knock it off. You're subverting the constitutional rights of American citizens, and you don't have that authority. We do. That is all I have to say. Yes, sir. Please comment, Mr. Swanson.
I certainly concede that we cannot broadly limit legal access to guns.
Well, then don't.
What we have to do is something more difficult, and that is to figure out who are the people who pose such a high risk of harming themselves or others that it is justified.
Mr. Swanson,
to
you're a
limit their
clinical
Second
psychologist, was in this field for almost 40 years, and you haven't figured it out yet? Then maybe you should look at a different vocation, sir.
I think we've made a lot of progress on that score, and I think we
We have not. Veteran suicide's increasing. That's not true. That is not true. We've spent $19 billion in 2023 on suicide prevention, and suicides are increasing. So your methodology has been proven to be bad, and I have no more time, sir. With that, I yield back. Thank you.
Thank you, Representative. I'm now going to recognize myself for a line of questioning. Ms. Keenan, thanks for your testimony. You mentioned that currently the VA sends the names of all veterans who have fiduciaries to the NICS, the NICS system. Can you explain why this violates due process and is harmful to veterans?
Thank you for the question. The VFW believes that veterans are owed due process in this process. It is clear, and we've discussed it today, that that is lacking in this process and unfairly discriminates veterans from a step further that is necessary to determine if they should even be referred to that list.
Thank you very much. You mentioned that the Social Security Administration does not report information to NICS of people who have been assigned a payee. Why is this?
It's our understanding that the Social Security Administration has a rigorous process if they are ever to do that. And at this point, the VA has a simplified process, and we think that doesn't go far enough to screen veterans, to look at additional medical evidence to understand if they should be referred to NICS or not.
And Ms. Keenan, finally, thank you for pointing this out. It seems to me that veterans are being held basically to a different standard than the rest of the population. They're simply being deprived of their Second Amendment rights, and I, as many of you do, believe that this is wrong. Can you elaborate on how this is a complete violation?
So the assumption that veterans are at more of a risk of violence or harm to themselves or others is in and of itself a harmful notion. Veterans, their rights should be protected. They serve this country to protect our nation's rights, and so we ought to protect their own individual rights. And our fear is that, as VFW members tell us, that the mistrust with VA and seeking mental health care is a major issue, and we need to take that into consideration with these policies.
And Mr. Lyle, you made mention of that as well, that there are veterans who do not seek the treatment that they not only have earned and deserve, but need because of fear of losing their Second Amendment rights. Can you expand on that a little bit?
Well, thank you for the question, Mr. Chairman. I think when you look at this problem in context, less than 50% or about 50% of veterans don't utilize the VA, or not enrolled in VA healthcare, and even less use it on a regular basis. I would assume that some of those veterans don't use it because there is a perception, now whether it's right or wrong, it's still felt true, that their Second Amendment rights would be infringed upon if they sought health care, not just mental health care, but especially mental health care at the VA.
Thank you very much. And Mr. Carey, we've heard that no other department or agency uses this policy of reporting to NICS, thereby putting into action whether the VA themselves are responsible for implementing it or not. It puts into action the process of violating Second Amendment rights of all of our veterans. Is there a special carve-out? Are you familiar with any special carve-out in the Brady Act, or is this just an overreach by the VA?
I was a Senate staffer back in 1998, and I remember when this is all going down. And what I remember is that the Clinton administration was concerned that there weren't enough names in the NICS database, which is a big part of the Brady Handgun Violence Prevention Act, and that they were looking at ways in order to be able to make sure that all the federal agencies were indeed reporting. Now, you know, the Department of Defense agencies that were talked about as reporting, that's the dishonorable discharges that they're reporting. They're not reporting mental health care cases. They're not reporting financial mismanagement cases. They're only reporting the dishonorable discharges. And Social Security Administration, you know, to the extent that they do find incompetence, they only find incompetence when when a court order says so, and they don't report. But as I understand, you know, during that process, basically VA was called upon to start, you know, to comment on their regulation and to say, well, hold it, we have all these fiduciaries. They should be classified as mental defectives, and we'll start reporting that. And that's where it came from.
Thank you very much. Ms. Keenan, one last question for you. I myself have hosted at my ranch in Montana several Wounded Warriors programs, and the hunters come out, and whether they're pheasant hunting for the day or deer hunting for the day, the Wounded Warriors program and the sponsors for the day typically purchase firearms for those veterans that they keep, they retain. So would then they be in violation of federal law or in conflict with this statute that is currently being implemented by receiving as a gift a firearm from Wounded Warriors program when they otherwise would be prohibited from going to the sporting goods store and purchasing one if they had been utilizing the services of a fiduciary?
That is a possible scenario, unfortunately, and if they indeed have been reported to NICS, that could be an issue for them.
Thank you so much, and I thank you all so much for your testimony. I will now turn to Ranking Member Takano if you have any closing remarks.
Thank you, Mr. Chairman, and thank you again for our witnesses. Thank you to our witnesses today for being here and contributing to the discussion. So, Mr. Chairman, at no time during this hearing have you heard anyone on our side of the aisle assert that the fiduciary program is infallible. No policy or program is, and to state otherwise would be disingenuous. However, what we have said and will continue to say is that any change to a program or policy must be evidence-based and data-driven. And in the case of VA's fiduciary program, a program designed to protect the most vulnerable veterans from both financial and physical harm, we must be especially careful not to put more veterans at risk. Democrats are more than willing to have a debate on the merits of this program under those parameters. Unfortunately, Mr. Chairman, this committee is embarking down a different path, and it is trotting out a highly charged, highly partisan bill that precludes us from having a reasoned and nuanced debate. I assure you, Mr. Chairman, that if you insist on pushing this bill through this committee, and perhaps even the floor of the House, it will die a quiet death in the Senate. And if, for some reason, it did pass the Senate, I guarantee the President will not sign such a faulty piece of legislation. So I implore you, Mr. Chairman, if you actually are attempting to address what you feel to be a problem, pull back from this course and let us get to work on a bill that may actually have a chance of becoming law and doesn't inject more bureaucracy or harm into the system. There is absolutely room for compromise on this issue, but it involves inclusion of things like lethal means training and safe storage and handling, and common sense ideas that are actually proven to prevent suicide. Sadly, I fear that my Republican colleagues would rather use this as a messaging bill to score cheap political points, because for some reason you are reflexively against those things. And so again, that begs the question, how serious are you about actually addressing this topic? The answer to that question has been made painfully obvious during this hearing, and it is not serious at all. Democrats stand ready to engage on this topic in an informed and reasoned way. But what Republicans have put forth here today is a philosophical debate about the absoluteness of the Second Amendment. They have made this argument in the absence of data to push legislation without safeguards that will have real-life consequences for veterans. Nowhere in these debates have Republicans presented an example of a veteran's firearm being confiscated, but they have perpetuated that fear. Nowhere in this debate have they even presented an example or any quantification of veterans assigned a fiduciary and subsequently reported to NICS that have asked for assistance. This bill is, a solution in search of a problem. But Mr. Chairman, it seems as if this committee is intent on letting politics win over sound policy, and to me, that is very regrettable, and I yield back.
I thank the ranking member for yielding back, and I thank the witnesses for being here today. I look forward to addressing the issues these bills are written to fix on behalf of the men and women who are serving our nation. With that, I need to also say that we actually did bring out a lot of facts on where we're at, that this is not about guns. I said that. This is about a constitutional right. I'm not trying to make political hay, neither are any one of my members on this side of the aisle, though it was said in the closing statement. What we are doing is we're trying to make sure that everyone, especially our veterans, receive the rights that they have under the Constitution and that they can keep those rights. That they have due process, not due process by bureaucrats. And you can say, well, that's not really bureaucrats. Yes, it is. You're bureaucrats. Everyone else has to go before a judge, a person that we have assigned in our judicial system to weigh the evidence of whether or not someone should have their Second Amendment rights removed. And the fact that we are doing this and have been doing this with those people who have served this nation to protect the rights for every other person out there it is not a problem in search of a solution, or solution in search of a problem. It is a real live fact that some people, matter of fact, what was the numbers here? Let me see. In 2022, 14,158 were ruled incompetent and then turned over to the next. Already this year, 8,431. Of that, going through the process in 2022, there were 12 that were reversed. In 2023 so far, there's been 2 that have been reversed. It is a legitimate issue. I unfortunately, in both the opening and closing remarks, which I hope were written by staff, basically said that this is not happening and that we're scaring veterans, but yet veteran service organizations are giving testimony that they are talking about this. They might not be talking about it in California. I think they probably are. But I know they're talking about it in deep southern Illinois and the other areas around this nation. That if discourages our men and women from that are veterans from seeking the help that they truly need, that is available and presented well. I want to be very, very clear. You can say that the VA doesn't take away their rights. They don't. They simply turn them over to the next list and they take away the rights. That's the way it works. But they don't have a judge to make that decision. All we're trying to do is make sure that the rights of our veterans are the exact same rights that every other citizens have. With that, I want to ask unanimous consent that all members have 5 legislative days in which to revise and extend their remarks and include any extraneous material. Hearing no objections, so ordered. This hearing is now adjourned.